key principle that's emerged out of this work is, again, over 20 years or so, is giving people the opportunity to take action and support to take action. So in other words, they're not simply making recommendations for government. They're doing that, but they're also saying, here's what I'm going to do as a volunteer or as a member of other organizations, businesses, nonprofits, faith communities, to do something about this issue. And then the final thing which seems to work is and the most recent thing is using online tools in various ways as a complement to, not a replacement for generally, but as a complement to face-to-face kinds of communication. So this, this type of work, you can understand the appeal to public officials who have been, scarred by past experiences with official public participation processes. And in fact, I never realized the extent to which this is an emotional issue, for public officials. I started working about 12 years ago with a group in the National League of Cities called the Democratic Governance Panel. So a set of about 30 local electeds who kind of were experienced with and champions of good public participation. And when I started working with them, I thought it was going to be kind of this intellectual exercise. We would be writing guides, and which we did all that. But at first, it was group therapy, because people talked about kind of having been elected to public office, I've been picked by my peers to make decisions on their behalf, and all of a sudden, 3 months in, everybody who you thought was your friend is now yelling at you, and it's, it's true that, and part of our problem as a field, I think, in general, when we're talking about trying to create more effective public engagement, we make these intellectual arguments, which are all valid, and yet we disregard what Pete was talking about, which is the emotional reasons why public officials are pretty jaded about what they understand to be engagement, and which is also an opportunity when you can kind of put them in a setting which is not, that awful 3 minutes at a microphone thing. They love it, but it's to kind of to explain that to them, and you got to be explaining it in these emotional terms, not just in the intellectual terms. So anyway, so as public officials and others of us were doing this work, this whole question about the laws has always been an issue. At first, it wasn't. It was more to do with the fact that when you put people in these more small group kinds of settings, and some of those people are public employees or public servants, the question of what is an open meeting, what needs to be televised, what needs to be recorded, all those kinds of questions have come up many times over the years. And in many cases, it's not really that the laws explicitly forbid or dictate anything in particular. It's often the case simply that the laws are so old, and so as Pete was saying, Brown Act in California passed in 1954. Pre-internet, obviously, and pre-everything else as far as how we do effective participation. So it's really more, in many cases, the fact that we don't understand, and that they don't define public participation. Terms like public engagement and participation often pop up in all these different laws, usually not defined, at least in ways one can use them. Principles of what good public participation ought to mean, also not there. So it's often a case that it's just unclear what the laws ought to be doing. And then when you get to city attorneys or other kinds of legal people within government, within school systems, understandably, by virtue of their profession, risk-averse people, and you come to them as a public staffer or public official and say, hey, I want to get the public involved and want to do X, Y, and Z, their default answer is going to be, no, you can't do that because we're going to get in trouble. So it's partly a question of not simply, partly the question of kind of clarifying what the laws really mean and kind of clarifying how the laws ought to uphold the values that we want to have, transparency, effectiveness, and participation, all those different kinds of things. So as you can tell, also so there's been this long-term kind of concern as far as this kind of new wave of public participation starting 20 years ago. That's only accelerated with all the online things. If you want to have a stand-up crowd, standing room only crowd at any conference of local officials, have a seminar, have a workshop on legal aspects of online engagement, they will line up into the hall because it's something they all think they have to do these days. They're getting this, they know, even local officials who really don't know, what Facebook is, and you see a definite generational divide. By the way, I'm 43, so I'm too old to have tech skills and too young to have people skills. So but But you see a generational divide. You know, a lot of local officials over 43 who understand that they really need to do online engagement, but they're scared to death of the open meetings, all the legal aspects. And so that this is a huge kind of concern now within the field. So anyway, so National League of Cities, also ICMA, which is the City Managers Association, you know, doing a lot of engagement work over the years, interested in this question. Then we kind of reached, I think, a tipping point in this issue when, in the wake of the Gifford shooting a couple years ago, the ABA passed a resolution saying that it ought to be was part of the role of lawyers, judges, the ABA itself, to promote stronger civil discourse. So this kind of provided a space within ABA where people could talk about, okay, well, what are the legal aspects of this, and start to kind of grapple with some of these, you know, this difference between good practice as we know it and the laws. So they formed a task force on stronger civil discourse, and people who, a lot of people got involved through that. So then, beginning of last year, as Janice was saying, a number of us who were interested in this kind of formed this working group on legal frameworks for public participation, which had representatives from NLC, ICMA, ABA, and then IMLA, which is the International Municipal Lawyers Association, which is the city attorneys group. So reps from those associations, and then a bunch of us kind of civic geeks who do this kind of work. One of the person I ought to name also in particular is a woman named Lisa Bingham, who's a professor at the University of Indiana, who's a professor of law and public administration, who's been our kind of main legal language drafter person. So a lot, when you look at the model ordinance and the state act, that's a lot of her writing there. So over about a year or so, we worked as a working group. It's been an all-volunteer activity. We've met a couple of times in person and done a lot of stuff online and over the phone. So what we've done is we've created that model draft ordinance. We've created that model state act, recognizing that in many cases, as in California, you have to deal with the state laws. You can't just do the local stuff. We have another document we're still working on, which has a kind of a set of policy ideas you know, that city governments might want to consider in terms of stronger public participation. And we've also worked on some kind of documents which kind of make the case for why this is important, including the Zocalo Public Square article that I think Janice may have forwarded before. In thinking about the ordinance, we took our inspiration, after a lot of discussion about this, took our inspiration from the ADR legislation, Alternative Dispute Resolution legislation, most of which was passed, whether state, federal, or local, most of which was passed in, you know, early to late 90s. And what it did, basically almost all of those laws, apparently, the way they work is simply to say, here's what ADR is, define it, here's principles of good ADR, and in the service of this definition, these principles, in order to kind of solve kind of legal disputes, you, members of the court system, may do ADR. You don't have to, but you can. So we kind of follow that example after a lot of discussion in something that is creating something that we thought would be more permissive than anything else. And so that's the framework you see in the ordinance is definition of you know, public participation, some principles there which come from, which kind of an amalgam of existing principles established either by International Association for Public Participation or National Conference for Dialogue and Deliberation, and a couple other things like that. But basically, you know, 6 or 7 principles. Here's what good participation looks like. And then the third piece is just saying, look, you know, under the guise of these, in the service of these principles, this definition, you may do the same old 3 minutes on the microphone you've always done, or you can do other stuff. So that's where what we've developed. One thing that I think is productive is that when cities start talking about this, generally, pretty quickly, the conversation becomes not what should our laws be, but what should our participation be? You know, what kind of system do we want? What kind of engagement scene, what kind of engagement opportunities do we want to have available to people? And then we'll worry about what the laws ought to be. And I think that's certainly a very logical and helpful way to do it. And I actually do think that, I mean, this is kind of getting into some bigger issues, but I do think that one of the things we need to think about and do more of as a field is to figure out how to do more engagement. Not more government-initiated, government-structured engagement, but more diverse types of engagement as part of a more well-coordinated system of engagement, which includes lots of opportunities that are for people that are more social, that are more youth and kid-friendly, that are more convenient, that are more regular, that are more online, that are more fun. That's the big question that a lot of the communities generally have to be dealing with. We have done a good job in this country of temporary issue-focused, decision-focused kinds of participation. We have not established long-term plans, systems, structures for public participation from the grassroots level to the city hall to the state house. We haven't created those kinds of structures. Those are the kinds of questions we need to be thinking about, and it's not just a government question. It's got to be something where you have different kinds of leaders in the community and all kinds of regular old people who are saying, here's what I want to have happening in my neighborhood and in my city, and here's how all of us, government, school systems, faith communities, neighborhood associations, foundations, here's what all of us can do to support that kind of much more vibrant, enjoyable engagement scene. So if you're interested in that, there's another document that you might be interested in. It's called Planning for Stronger Local Democracy. It's a publication of the National League of Cities, and it takes people through a kind of a planning process which looks at the legal infrastructure as only one piece of a bunch of other things that you might want to think about in creating that kind of better kind of engagement picture. So having said all that, I also want to tell you, though, that I was in one city recently in California. I can't name the city, but where I was in a meeting prompted by this new ordinance, meeting with a city council member and city clerk, city attorney, their staff. And we were talking, and the conversation was taking this same kind of tack of, okay, well, let's not worry about the laws yet. Let's think about what kind of participation scene we want to have in this community. And then finally, at one point, the city attorney said, yeah, okay, that's great, but another way to do this might be to break the law. And so they started concocting some strategy where they would take some kind of productive public participation exercise that they knew was in violation of the Brown Act and do it and get themselves sued, and out of the resulting kind of furor, kind of make a case for why these laws were in fact not reflecting what ought to happen. So, I thought that was kind of a nice, I don't know if they have the guts to do it, so that's why I'm not going to tell you what the city is, but I thought that's quite interesting and other kind of approach that would bring these ideas up.
So the questions, are there unique models for student group cooperation with public policy?
Well, yes, I'm sure, we probably all know some of them. One of the best long-running examples is Hampton, Virginia, which is this Hampton Youth Coalition and Hampton Youth Councils, which are quite it's been in place now for, 10, 15 years, which has been a great not just an educational process for young people, which is important, but also kind of valuing the potential of young people as engagement leaders in the present. And that's an important shift. And so there's lots of really good temporary efforts which have had young people as kind of leaders of them, and I think that's really important and too often overlooked engagement capacity is, when young people are in charge of something or they're kind of visibly out front, they attract all kinds of people of all kinds of ages. And so that leadership potential of we can't just be thinking about them as leaders of tomorrow, which of course they are, but leaders in the present, if you're trying to engage the public, is an important thing not to overlook.
I might just add, and this isn't so much student-based, but it is certainly university-based. I mentioned before that this is a real trend in schools of public policy and public administration coursework in this area, and I happen to be on the steering committee for a group called the University Network for Collaborative Governance, which is a network of about 25 or 30 university-based centers that are dealing with these issues of both intergovernmental and government-to-citizen collaboration and participation. And I think that this really is one of the more exciting areas. Obviously, I'm based at a university, but a trend that we've really seen over the last 5 or 6 years in public administration and public policy is the development of coursework in this area. And I think you're even starting to see municipalities, and I know of a couple, who are making this a core competency, the ability to either facilitate meetings or to lead a public process. I'll never forget, we had a conference at Pepperdine a couple years ago in sustainable planning and development. We had the then, no longer, but then director of LA City Planning say in a panel, and I'll just quote it because I'll never forget it, is we always put people up in front of the public who are the least prepared to be there. And what she meant by that was not that her planners didn't have expertise in planning, but they really didn't have an expertise in how to engage a public in a conversation around the planning decisions. And I think you could extrapolate that statement across a lot of different departments and a lot of different levels of government. But I think it is encouraging that both for the present and certainly future leaders coming out of schools of policy and public administration, that this is something that's being addressed.
So the question's related to, given our current legal system, our laws, how could we use the online space for engagement? And what tools are available?
Well, we've seen a few public bodies that have implemented Facebook pages for their public bodies, and a couple of public bodies we know of have rules for public engagement on those. Unfortunately, they're not entirely, from our perspective, constitutional, because because they reserve the right to remove some of the statements. And I mentioned this earlier, but in our limited passive and reactionary participation process of the 3-minute presentation in front of the council meeting and public comment. Illinois just recently codified, due to the efforts of Benedictine University and Citizen Advocacy Center, we codified public comment in Illinois public meetings. And there's only something like 10 states that have it codified. So again, it's not wonderful that it's limited to 3 minutes, but we wanted that the rules of the game at least be published by all the public bodies, because they weren't publishing the rules of the game, and they were kicking people out for things like rolling their eyes or sighing loudly. And so the provision requires that public bodies actually post the rules of the game so that the public's aware that they have the right to comment and what what the rules are, how many minutes they have. Unfortunately, some of those rules have constitutional violations in them because they restrict content-based speech. They want the people to be nice. Well, of course we want people to be nice, but the government can't legislate niceness. I mean, that's something that you learn in civic education or, through efforts towards civil discourse and whatnot. It's not something that the government can mandate, and certainly against our Constitution.